hearing file 2124262 People versus Brownman. The court's been advised that although motions are filed in this case to be heard today, that there has actually been a plea negotiated. And now we're moving forward with a plea today. Is that correct statement, Ms. Cook?
Yes, Your Honor, it is.
Mr. Palino?
That's correct, Your Honor.
And with the prosecution, please state the agreement as they know it on the record.
Your Honor, it's my understanding in this case, the defendant, Dennis Lee Bowman, will be pleading no contest to murder in the second degree as a habitual offender's second offense notice. That is a felony level charge and a life offense. The people have provided the court with a packet of stipulated facts for the plea agreement. We have provided that to the defense. They have reviewed it. Both Mr. Catalino, myself, and Mr. Bowman have signed the court's copy. There is a 3-page statement of facts that go along with that, a photograph, a letter from the defendant, and the post-mortem examination report from Dr. Elizabeth Douglas of WMed, the anthropology report authored by Dr. Jared Cornelison, as well as the certificate of DNA analysis from Dr. David Foran of the Michigan State University Forensic Biology Department.
Thank you. Mr. Palino?
Your Honor, that's a correct statement of the plea agreement in this matter and how we intend to proceed forward. I do have, for the record, I would just indicate that defense counsel has reviewed all of the statement of facts before Mr. Bowman signed it, as well as all of the attached exhibits, and he has freely and voluntarily affixed a signature to that in our presence. I do have an advice of rights that I've reviewed with Mr. Bowman, and he's executed.
Thank you. Not included in the stipulated facts unless I missed it, and I may have. The agreement includes a habitual offender second. There's no stipulated fact regarding prior conviction in that stipulated facts. And I will address that on the record, but it's my understanding that that is also for the plea.
That is correct. He only has one prior.
Yes, and I believe the amended felony information, it recites it except for a typographical error of the year. The year should be, I believe, 1999 rather than 2999. We would stipulate to that further amendment, Charlie.
Thank you.
Is this, well, this is the court. I don't have the last information in the file. So what is it the issue in regards to a conviction breaking and entering?
Yes.
That was in this court, circuit court for Alger?
Yes.
Mr. Baumann, did you hear what the attorneys have said about a plea agreement?
Yes.
Is that your understanding of the agreement?
Yes.
Do you have any questions about it?
No.
Anytime you're sworn in, if you would raise your right hand, you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth.
Yes.
Mr. Baumann, do you understand if you are not a citizen of the United States, conviction of a crime could result in deportation, exclusion from the United States, or denial of naturalization?
Who's not a citizen of the United States?
Are you a citizen of the United
Yes,
States?
ma'am, I am.
All right. Are you, and you're currently not on probation or parole, correct?
True.
I'm going to restate the plea agreement to make sure that I have it correct. It's my understanding that you're pleading no contest to murder in the second degree as a habitual offender second. Do you have an amended information for this?
No, Your Honor. I will provide that to the court.
All right. That's a life offense felony. The maximum amount of time you could be incarcerated is life. It's my understanding that if you plead no contest to that charge, the prosecutor's office will dismiss the balance of the file. Would that be, what count would that be? I don't have the last information.
The last information is count 1 is open murder and the habitual offender second. That's all that's on the information.
So this is just count 2.
Correct.
So it'll be designated as a count 2. And the court is going to review a variety of documents to determine a basis for the no contest plea, a factual basis. And the parties have stated what those documents are. Do you understand, Mr. Baumann, that a no contest plea will result in a conviction when we found guilty by the court?
Yes, ma'am.
Did I state the plea agreement correctly?
Yes, ma'am.
I do plead to the charge of murder in the second degree as an habitual offender second.
I plead no contest.
What is the basis for the no contest plea, Mr. Catalino?
Potential civil liability and because of the age of the offense recollection.
Thank you. Mr. Baumann, you do have rights. You signed this paper, correct? This is an advice of rights form. It contains all of your rights in this court. By accepting this plea agreement, you're giving up every single right that was done in that paper. You will not go through trial at any time. Do you understand that? Also, you may be giving up issues that would have been appealable if you'd been found guilty at a trial. Any appeal from this plea and conviction and sentence would be by application for leave to appeal and not by right. Do you understand that? Are you willing to give up all of your rights in exchange for the plea? Have you been promised anything else other than what we have said in court today? Have you been threatened, forced, coerced in any way to plead no contest?
No.
Are you doing this of your own free will?
Yes, ma'am.
As indicated, the court has received a variety of documents. The first is a stipulated facts document in regards to the plea agreement. The stipulated facts indicate that they're derived from a police report. Complaint number 31289-89. That on or about March 11th of 1989, the defendant came home to his address in Holland, Michigan, Allegan County after dropping his wife off at work. When he was there, he had contact with Andrea, his adopted daughter, was packing her things to run away from home. The defendant admitted that Andrea was running away and going to tell the defendant was still sexually assaulting her. The statement angered the defendant. He admits he said, "No, you are not," and he punched her in the face at the top of the stairs. She fell backwards down the stairs. He said she made a hell of a noise going down the stairs, that she moaned while in a heap at the bottom of the stairs. The defendant admitted that Andrea is dead because of me. He stated he was an ex-con and did 3 years in prison for assault with intent to penetrate. Andrea had accused him of sexual abuse previously, and she is now on the floor dead with a broken neck. So he knew he would be arrested for her death. He did not seek any emergency aid or call authorities to provide medical care for Andrea. He moved Andrea's body to the barn located on their property, covered her with a tarp, and burned her coat and the bag she had packed when she was planning to run away. He then called the police 1 hour later to report she stole money from him and that she was a runaway. He also signed a missing persons complaint for Andrea, knowing she was already dead. The defendant gave multiple versions of what he did with Andrea's body, stated he did not want to look like a monster in his wife's eyes. However, ultimately, he admitted he had to get rid of her body. After 2 days, he decided to dispose of her body in a barrel to put out with the rest of the trash. She would not fit in the barrel, so he had to cut her legs off. He attempted to use a machete to cut off Andrea's legs, but it wasn't sharp enough. He never cleaned the machete, but stored it under his bed and continued to use it for other purposes over the years. He admitted he used a single blade axe to chop off her legs. He then put her body in a cardboard barrel and buried it on their new property located at 136th Avenue, Hamilton, in Michigan, Allegan County. He buried the barrel with Andrea in a hole 3 feet deep and had a cement slab placed over the top of it. He told his wife she would not stop bitching about where Andrea was. Now she knows, and he put Andrea in a can on the mantle. He added, "Now you know what a rotten son of a bitch I am, and I've been lying to everyone about this case." A search warrant was executed at the Bowman residence on February 5th of 2020. After moving the slab of cement, the remains of a barrel were found. The dismembered remains of Andrea were located in 4 plastic bags within the barrel. Also located was a bag of garbage, including used diapers. 1 plastic bag contained the skull and first 2 cervical vertebrae wrapped in a textile fragment. In the second bag, Andrea's upper torso, pelvis, and upper extremities were discovered. In the remaining 2 plastic bags, each contained bones of a lower extremity. In addition to the stipulated facts, there are reports to support the stipulated facts that have been presented to the court. The forensic postmortem examination by Dr. Elizabeth Douglas, forensic anthropology report by Dr. Jared Cornelison, and that is spelled Cornelison. Certificate of analysis of DNA by Dr. David Foran, Foran. And there was also Andrea's remains identified using a DNA comparison with her biological mother, Kathy Tarkarian. The defendant continued to help his wife look for Andrea, even though he knew she was dead, posting missing person posters and driving around searching for her. He said people had sightings of her and he wanted to scream and call them idiots. He knew she was dead. He stated he never told anyone what happened because he'd been told by a prison psychologist the only way to keep a secret was to keep it to yourself, and he knew he had to keep his secret. The court does have the photo of the burial site. Also a statement written in the defendant's hands that is dated November 7th of 2019. It says to friends and family, because of my present situation, because I love my wife and daughter, I'm writing this explanation that you, my loved ones, have to hear. I have confessed the death of my daughter, Andrea. I myself and no one else. In an argument with her, I struck her, which made her stagger backwards and fall at first on a steep staircase in the house we rented in between Holland and Hamilton. Fearing more prison time and losing my loved ones, I hid the body and then disposed of it. Days later, I have kept this to myself for these many years so I could live with my life with Brenda and watch Vanessa grow into a successful young lady. Please, with all love, I ask you to support Brenda because I have caused her heart and left her desolate. She didn't deserve this and has always loved me beyond measures, shame beyond words, Dennis. There's also a post-mortem examination report by pathologist Elizabeth Douglas, MD. The report indicates the cause of death is homicide at unspecified means, and that there was confirmation of the skeletal remains by confirming the relationship with Catherine Turkanen, who was the biological mother of Andrea Bowman. Understanding that the parties agreed that and would stipulate that Mr. Bowman has had a prior conviction for breaking and entering with intent to commit crime of larceny, and felony conviction from March 9th of 1999 in the Circuit Court for Allen County. I expect you to believe the court has articulated a factual basis for this no contest plea.
Yes, Your Honor, I do.
Mr. Catalino,
Yes, Your Honor, I do.
do either of the attorneys know of any other promises, threats, or inducements related to this plea on those already stated on the record?
No, Your Honor.
I'm aware of none, Your Honor.
Do you believe the court is compliant with the court on taking this plea?
Yes, Your Honor.
Yes, Your Honor.
Thank you. Mr. Bowman, the court believes there's a factual basis presented to the court. The court's going to accept your no contest plea and enter it. We'll set this for sentencing.
February 7th.
February 7th at 8:30 a.m. Anything further from either party?
That's my knowledge, Your Honor. Thank you.
The court is going to retain the documents presented, so the probation department will have those available for the pre-sentence investigation report. We are adjourned.
Thank you.
All right.
Just have a seat, you got a card right there. This is Joe.